Good afternoon, this is Mr. Lipchick, and the topic of our discussion for this segment is the basis for citizenship. On what is the concept of citizenship based, and what are the qualifications? Okay, let's first talk about national citizenship. Today's concept of citizenship has both national and state citizenship dimensions. The Founding Fathers, however, assumed that the states would decide who is a citizen of their state or not. And citizens of the states would also be citizens of the United States. The exceptions were African Americans and immigrants who became citizens through naturalization. Naturalization is the legal process by which a person is granted the rights and privileges of citizenship. So naturalization applies to people who were not born here. Okay, very important case involving citizenship, and the basis for it was Dred Scott versus Sanford in 1857. Dred Scott, of course, was a slave who was suing for his freedom, claiming that he had lived in a free state, which made him free. And one of the arguments of Chief Justice Roger Taney to deny Scott his freedom was that African Americans could not be citizens because they were not U.S. citizens at the time the Constitution was adopted. And only the descendants of people who were state citizens at that time or became citizens through naturalization were U.S. citizens. And this case confirmed that citizenship had its basis in state citizenship at that time. Okay, so early on, citizenship had its basis in the state. The 14th Amendment, passed in 1868, however, overruled the Dred Scott decision. It clearly established what constitutes citizenship at both the national and state levels. State citizenship became the result of national citizenship because of this amendment, which was passed to keep states from mistreating freed African Americans. And this states all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Okay, so now citizenship was a national affair. Okay, citizenship by birth. There are three basic sources of citizenship: birth on American soil, naturalization, both of these stemming from the 14th Amendment, and being born to a parent who is a U.S. citizen. The law of the soil states that basically nearly all the people born in the United States and its territories automatically have U.S. citizenship. An exception is given for children born in the U.S. to people not subject to jurisdiction, such as foreign diplomats. Citizenship by birth to an American parent. This is called by law of blood or jus sanguinis. If a child is born to an American parent in a foreign country, he or she is a citizen, provided that one of the parents has been a legal resident of the U.S. at some point in his or her life. And if only one parent is a U.S. citizen, that parent must have lived in the U.S. for at least 5 years, 2 of which must have occurred after age 14. So they want to make sure that people who have been disconnected, by a great deal of time from the U.S. do not become citizens, just by virtue of birth. Most of the steps in the naturalization process for immigrants to become U.S. citizens is administered by the U.S. Citizenship and Immigration Services. There are qualifications for citizenship. 1. You must have entered the U.S. legally. 2. You must be of good moral character. 3. You must declare your support of the principles of American government. 4. You must prove that you can read, write, and speak English except for residents over 50 years old and who have lived here for over 20 years. And you must demonstrate basic knowledge of American history and government. There are steps to citizenship. The applicant must do the following. Okay, reach 18 years of age. Live as a lawful resident alien for 30 months out of the previous 5 years. Live in the state where the petition was filed for at least 3 months. And if married to a U.S. citizen, he or she only needs 3 years of residency to file. There are key steps in the naturalization process. An investigation and preliminary hearing in which the individual is questioned about his or her moral character. They're going to look and make sure that an individual is not a criminal. 2 witnesses are asked about his or her character and integrity. They may be asked to demonstrate a grasp of the English language, American government, and U.S. history. If they pass a preliminary hearing, they will be asked to attend a final hearing at which they take the oath of allegiance before a judge. They must renounce loyalty to their former government and agree to obey and defend the Constitution and laws of the United States, to bear arms on behalf of the United States when required by law. That means accept membership in the military service if drafted. And after their oath, the judge issues them a certificate of citizenship. There have been exceptions in the naturalization process, primarily through territorial acquisition. When members of an entire group of people living in a geographic area become citizens, it is known as collective naturalization. They do not have to go through the naturalization process, and they are granted citizenship through an act of Congress. This has only occurred 5 times. The Louisiana Purchase in 1803, we purchased the Louisiana Territory from France. The purchase of Florida from Spain in 1819. The admission of Texas to the Union in 1845. Texas was its own republic for a brief period. And is when citizenship was conferred upon Hawaiians in 1900. And after the Spanish-American War, one of the territories that the U.S. seized was Puerto Rico, and they were granted citizenship in 1917. In 1868, Congress decided that the 14th Amendment did not grant citizenship to Native Americans. Individual grants of citizenship were made to Native Americans who gave up their traditional lifestyles. Not until 1924 did Congress make all Native Americans citizens of the United States. Losing citizenship can be removed from a person in certain circumstances. Expatriation. There's voluntary expatriation involved becoming a citizen of another country, automatically giving up your U.S. citizenship. If you serve in a foreign military or swear citizenship in another country, you are no longer a U.S. citizen. Involuntary expatriation occurs when parents of a child become citizens of another country. So your parents can choose citizenship for you. Also, punishment for a crime. Conviction of certain federal crimes that involve extreme disloyalty, such as treason, can result in a loss of citizenship. Denaturalization is a loss of citizenship for using fraud or deception during the naturalization process. And to the right, you see a picture of John Dominic, who, while not found guilty of war crimes in the United States, was found guilty of falsifying his immigration papers and was forced to lose his citizenship and leave the country. There are responsibilities of citizenship: respecting the laws and exercising citizenship rights, participating in our democratic institutions, and voting and being involved in the political process. That concludes our discussion for today. Thank you for your time, and I look forward to seeing you in the live lesson. Have a great day.